Of Ghana is a Nigerian girl pleasure, bringing you political news in our channel, Ghanatube. As we are committed to bringing you all the happenings in Ghana, here are some of the recent happenings. Please watch.
Attending or returning from or any proceedings of Parliament. Mr. Speaker, the standing orders, Mr. Speaker, even does the job. Starting from Order 25, which is titled Matters Relating to Criminal Processes. Mr. Speaker, it is very important that we emphasize that contempt proceedings are quasi-criminal. In other words, it is like criminal. Mr. Speaker, when you look at Order 25.3, it says that where a member of or the clerk to Parliament is convicted by a court of competent jurisdiction, the registrar of the court shall within 12 hours after the conviction inform the Speaker of the conviction. Mr. Speaker, do you have any notice from the court? No. Mr. Speaker, do you have any notice from the court? No. Mr. Speaker, it is very important. Mr. Speaker, it is very important that we do not go searching newspapers. We do not go looking at newspapers or listening to news to be finding out which member of Parliament has been convicted. Mr. Speaker, that is not our job. Our job, very respectfully, is to come and represent our constituents in Parliament and serve as legislatures. Mr. Speaker, if there is any conviction, same will be served on you. Until that is done, Mr. Speaker, very respectfully, it does appear that what we are being fed in this house by the distinguished, by the venerable majority leader, would does appear to be a hearsay. Very respectfully, Mr. Speaker, Parliament does not dabble in ake. Yes, say. Parliament does not dabble in ake. Yes, say. Mr. Speaker, unless there is notice, very respectfully, what has been brought before you, Mr. Speaker, would seem to be ake. Yes, say. Mr. Speaker, Order 25, Rule 5 says that failure of the registrar to inform the Speaker constitutes contempt of Parliament. Mr. Speaker, it may seem that the majority leader is bringing to attention contempt of Parliament by the registrar of the court. If there is any such conviction, is that what the majority leader is doing before the court? Venerable majority leader, distinguished majority leader, is it that you are bringing to the attention of the court contempt of court by the registrar of the court? Or are you now the registrar? Very respectfully, Mr. Speaker, in the circumstance of this, Mr. Speaker, this Parliament cannot trade in ake to disenfranchise or disallow a member of this house from performing his legislative duty. Very respectfully, Mr. Speaker, I'm very grateful. And in conclusion, I want to thank again the Venerable Anodompre, the MP for Isawama Dwejiri, for the encouragement he's giving to the backbenchers. Honorable, we are grateful.
Yes. Mr. Speaker, the honorable member who just spoke, he cited Order 25 of our standing orders. Mr. Speaker, Order 25, 24 deal with the service of processes. We're not talking about the service of processes. We're not. Mr. Speaker, secondly, Order 25 talks about detention. Subject to Order 24, where a member of or the clerk to Parliament, where a member, please listen, where a member of or the clerk to Parliament is restricted, detained, or arrested the person responsible for the restriction, detention, or arrest shall within 6 hours of the restriction, detention, or arrest inform the Speaker of the restriction, detention, or arrest. Has the man been arrested? Has he been restricted? Has he been detained? So how does Order 25 come into play? Mr. Speaker, here we are talking about, Mr. Speaker, here we are talking about a conviction. A conviction. He has been convicted. He has been convicted. Mr. Speaker, I know because he is defending his right to speak here, because he says that even if he has been convicted, if we have not been properly served, then we should not deny him a right to speak in this chamber. That's what he's saying. He is not denying that he hasn't been convicted. Nobody in this chamber is denying that he hasn't been convicted, because they know he has been convicted. It is public knowledge. It is common knowledge. It's been covered widely by the media. And my argument is that this house must respect a coordinate branch of government. We will not arrest him and hand him over to the judges. We will not arrest him and hand him over to the prisons authorities. But we will not condone him coming here and boldly making statements on the floor of this house as if we don't care about the judiciary and what they are doing. It doesn't speak well of the rule of law. There's somebody who knows very well that he has been convicted by the courts for a conduct that he engages in this house, and we caution him in this house. We say, look, there is a court order restraining you from being sworn in. If you refuse and you allow us to swear you in, you will be held accountable. And he said yes, he's ready to be held accountable. Now he has been held accountable by the courts, and he wants to come and use this parliament as a shield. Mr. Speaker, it won't happen. This side will not allow that. We will not allow him to make the statement on this floor, because he has been convicted by the courts. At least he should go and file an appeal. He should file an appeal. He should seek to stay the execution of the orders of the court. Then we know that due process is being complied with. Mr. Speaker, I want to indicate clearly that if you insist and admit this statement and you allow him to make the statement, this side of the house will wash our hands off, and then we'll walk out and leave you to make your statements. We'll wash our hands off, because we don't believe in undermining the judiciary. We don't believe in undermining the rule of law. We will not join you to undermine the rule of law. We will not join you to undermine the judiciary. We will wash our hands off, and then we'll leave the chamber.
Mr. Speaker, I was watching proceedings from my office, and I heard you call the member for Akutia to make a statement which you've duly admitted. Upon calling his name, the majority leader and leader of government business rose up, relying on Order 20 and Article 127 of the Constitution. He argued. First leg of his argument, inviting you to uphold the dignity of this house and generally to help in respecting the independence of the judiciary. Let me say that those submissions he made, though are legal submissions, but I find those submissions very rich in the context that he submits same on this House floor. Mr. Speaker, first, the applicant. In October 2024, a matter arose regarding some vacant seats. I, as a leader of government business, feeling dissatisfied, and upon reading the Constitution, felt that the right place and forum was the Supreme Court. Mr. Speaker, the majority leader, who was a de facto legal advisor to the then minority front bench, was very much aware of the matters in issue. I first sought an ex parte relief. I first applied to the court, invoked the jurisdiction of the court through an ex parte application, and made all the matters known to the court, and the court ruled in my favor. That order of the court staying the decision of the Speaker, which stay of execution allowed the majority to stay in its place, was forcefully challenged with all the energy from